Or good evening, everyone, and welcome to another edition here of the Justice and Pieces guest speaker series. And today we are joined by Kavita Bhagat, who is a family lawyer, and she is a certified specialist in family law by the Law Society of Ontario, an accredited family mediator, arbitrator, parenting coordinator, and a former panel lawyer for the Office of the Children's Lawyer. So thank you, Kavita, for joining us here today.
My pleasure. You did pronounce my last name right. Thank you.
I worked hard. It was
for that.
So perhaps you could start by giving us a background of all your work in family law and all the different aspects of it.
Sure. So I came into the country, I think, around 2006, 2008, and went through the NCA process before I became a lawyer here. Prior to that, I was called to the bar in India as well as the UK, but my primary focus was business, international business, and my eventual goal was to get to the UN. My career here was honestly just, I think by fluke, I ended up knocking on various doors and ended up at Legal Aid Ontario up in County Court Boulevard and was asked to be a volunteer, which was by chance. I was in the waiting room and people started walking in from all walks of life. The first client that walked in was a Punjabi speaking client and the staff had no clue what they were saying. So I offered to translate for them. The next client was a Sri Lankan client and I offered to translate because I speak Tamil. The next client was Urdu speaking and I offered to translate. I do speak 7 South Asian languages, 6 fluently, the last one not so fluently. So the end result was Maureen Hastings, the area director of Legal Aid at that time, offered me a volunteer position with Legal Aid, which of course resulted in tons of contacts. And from there on, after I completed my NCA process and was called to the bar, I reached out to one of the contacts because I wanted to article. My articling was completely waived, but I felt like I was being thrown into the dungeons, literally not knowing how I'm supposed to practice law in this country. So I wrote to the Law Society and said, nah, you can't do this to me. Like I need to be able to get some mentoring. And I reached out to Marty Klein and I eventually ended up articling with him for 4 months. And by the 5th month, I was doing a trial with him, which was interesting. So it was an amazing experience. And I honestly owe a lot to him, gratitude. He's now retired, off living in Roatan, which is amazing. But that was my foray into family law. And from there on, I started my practice. I worked with a lawyer for about a year, but I soon realized that working in a firm was not an option for me because as a mom, I needed tons and tons of flexibility. And I had given birth to premature twins at 6.5 months, which required me to take some time off. But I'm very passionate about the work that I do. So I essentially set up my office space with a nursery in the office itself. And I started working and all my clients from my previous firm, all 100+ clients walked and they walked to me. So I couldn't handle that. And I hired a lawyer. And then within 2.5 years, my firm grew into 12 people. So I had 6 lawyers and 6 staff working for me. And long story short, by 2014, I was fed up. I love the practice of law. I hate the business of law. It's something that I truly stand by. And I found that I didn't have enough time to pursue my passions because all I seemed to be doing was bringing in the clients and handling the admin. And it took me away from what I wanted to do. So we decided to downsize, and we're now a 2-lawyer firm with a revolving door of interns and NCA students, etc., who want to be with us and learn with us, basically. That is the model. Truth be told, as I was telling Rochelle, sometimes we have more dogs in the office than we do human beings. That's the reality of life here. But it's good fun, and we do have lots of kids coming in and out the door as well. In terms of my family law experience, in order to become a certified specialist, the Law Society requires that you tick off lots and lots of boxes, essentially over 30 check marks to satisfy the Law Society that I have handled every complicated matter possible to basically deserve that designation. And they check in with us every now and again, but we have to provide concrete proof of it. So it could be, have I done a trial? Have I attempted to settle a matter? Have I handled pension-related issues, complicated custody issues, all kinds of matters. But I'm very proud to say I truly love and am passionate about family law and handled pretty much everything that's thrown at me or which comes through the door.
And what about the mediation and arbitration aspect? When did that come into the picture?
So I have a reported decision called Choker versus Baines, and I can talk openly about it, of course, because it is reported. In that particular case, which was closer to around 2012, my client was a victim of domestic abuse. And we took the matter to trial. And on the day of the trial, when my client was to be cross-examined, the husband fired his lawyer and chose to cross-examine my client personally. The result was that my client completely clammed up and would not speak. And the judge doubted her credibility with respect to all of the issues. Unfortunately, the judge did not have enough experience with respect to domestic violence issues. And we had a favorable decision for the most part, but one of the key factors we lost on. And it is then that I realized that, you know what, I need to be able to offer my clients a very different process. I do believe that domestic violence, despite it, sometimes mediation might be the right solution if you are able to put the right protocols and measures in place and provide that alternate avenue. So I decided to sign up and pursue my course in mediation in the year 2014. And about 2018, I also decided to pursue my arbitration course. And in 2020, I completed my Voice of the Child training to be able to incorporate interviewing children during the process of mediation as well.
Now, as you may know, certainly paralegals and my paralegal students right now, where it's not an area within their scope of practice, so we don't really study family law as a result. So perhaps maybe you can give us a brief overview of what the family law process is like from an intake to potentially a trial, so then we can look at where you're mentioning alternative dispute resolutions and where it comes into play in family law.
So with the changes to the Divorce Act, alternate dispute resolution is something that will definitely have to be incorporated or at least suggested to every client if they are choosing to pursue court proceedings. We definitely have to make that recommendation come January of 2021. There are no two options there. In terms of when the client comes through the door or even during the initial consultation, because I wear multiple hats, I tend to have discussions with the clients to offer multiple options. So I haven't, I completed my collaborative training as well. So sometimes I will offer to the clients, not sometimes, all the time, I'll explain to the clients the multiple options available. The first option would, of course, be mediation. The second option would be collaborative law. The third option would be court. And of course, during the entire process, there is definitely the option of trying to negotiate an agreement. The client intake process for me tends to take the longest time. And it's during the intake process that I make the determination as to what the best process is for the client. I find that my role as a lawyer is not to decide the process, but to offer information with respect to the process and say, these are the options available. This is what I would suggest. However, it's up to you to give me instructions and choose the process that's fit for you, because I've only known you for less than an hour and you are the right person to make that decision. I often compare that process to going into a surgeon's office and the surgeon suggesting, you know what, you can hold off, you can go for physiotherapy, we can treat it with medication, or let's go in for a minimal surgery, or let's go in for amputation, right? At the end of the day, that choice truly lies with the client and they have to make that ultimate decision. So I find that in order to practice family law, I say this to every person that walks through the door, be it an NCA student, a paralegal, or person, any kind of person who comes through the door with an interest in family law. You have to have a strong heart. You need to be able to switch off when you go home, because family law is not for everyone. The burnout rate is extremely, extremely high. Your emotions do tend to get entangled. You tend to get personal, and you have to be very aware of that if this is the career or this is the field of law that you want to get into. Would you like me to go on about the entire process till trial?
Sure. Let's maybe look at what happens from after the intake. Let's say you're representing one of the person who is, let's say it's a divorce, let's say, right, or who essentially wants to initiate the proceedings, or and so you could also touch upon some of the other different aspects of family law besides divorces that you may encounter in your files, and let's look at maybe the next stages, and then we can kind of build on from there.
Sure. So for the purposes of this explanation or discussion, I'm going to presume that the client's walked through the door and she's picked the option to proceed with litigation. If it's litigation, usually what would happen at that point is that after the initial intake, we would provide our clients with a checklist of financial documents that they would have to put together. The financial documents sometimes can tend to be pretty overwhelming, because for family law purposes, you're looking to provide us with information pertaining to the date of marriage, the date of separation, and the current day information. So most clients, especially if it's a long-term marriage, tends to be a very, very, very overwhelming process. And we also need to appreciate that, a breakdown in a family relationship as it is taking a massive emotional toll on them. So their ability to focus and get these documents to us in a timely manner is lacking, is truly lacking. So we tend to explain to them that the easiest process is perhaps for them to sign up for online web access. So we encourage them to get a CRA web account, banking institutions web account, attend, and then my staff or I would usually sit with them and help them log in and get the information ourselves and provide them with due assistance in completing the financial statement, because financial disclosure is undeniably the fundamental tenet of family law, and there is no escaping that process at all. And while all of this is happening, we're still trying to ensure that the status quo in the home with respect to finances or the children and the day-to-day activities at home are maintained, and the hostility is in control. The acrimony doesn't just explode, and we are in communication with opposing counsel. As a matter of practice, I will always, always, always pick up the phone and call opposing counsel. If there is already counsel, just to say, hey, how are you? I'm on board. Do you want to have a chat with me? If at any point of time you feel that we can have without prejudice discussions, or you just want to yell at me because I wrote something to you, I'm happy for that to happen. I'm a firm believer that this is our livelihood, but outside of court, we need to be civil with each other. So I always, always encourage that. Once the financial disclosure is exchanged, we will also sit down with the client. And usually, again, this takes about 1 to 2 hours. They've already been given a checklist to prepare a chronological summary of the key events in their lives. And once we have that chronological summary, we bring them in to kind of elaborate on that. What we find is if we tell them to write a story, I can tell you the last time the funniest was when I had somebody write about 200 pages and bring it to me. And I looked at it and I was like, I get it. I know it's a 32-year marriage, but God knows the judge is not going to be interested in this. So after that happened, we now make it a point to get them to just provide us with a chronological summation of the major events in their lives. And once they bring it in, we sit with them, get them to elaborate and draft the pleadings based on that with them, which usually tends to take about 2 hours again. And then we draft the financial statement as well with them at the same time in our office. We discuss the process with them and we file it. Now with online filing, the clients, there's this joy in their faces when we show them that we're clicking the button and it's actually going into the court right away. And then we receive that email back from the court simultaneously, hopefully. And then after that, we explain the process. Again, an informed client is the best client that you can have. So I'm always, always in favor of giving a lot of information to my clients. I have all kinds of flow charts that I prepare to explain the court process to the clients, the intake process to the client, the disclosure process to the clients. I feel that when I have that visual, the questions that they ask are a lot lesser because they're so well informed about the process itself. So that's critical. And honestly, that reduces our law society complaints and our law pro complaints as well. So, it's critical that we keep our clients apprised of everything that's happening and provide them with what's going to happen, not just tomorrow, but going the next couple of months and in years to come as well. So the flowchart has details about every step in the litigation and what's required at every step so that they don't turn around tomorrow and say, hey, you didn't tell me that now that I have a new job, I was supposed to inform you. So that's very critical to the process, of course. Once that's done, once we have prepared all of it, the other side has about 30 days to respond to the proceedings. I also believe that, while we are taking an aggressive stance and going to court, most of my applications, at least 60% of them, I find there's merit to making an offer to settle from the get-go. Because when I do an offer to settle, most people are intelligent enough that they want to avoid litigation expenses. So when they consult with a lawyer who hopefully is sensible or whoever, like they look at it and they say, this isn't bad. Like, I mean, she's not screwing me over, pardon my French, but, at least they will have a sense as to what we are looking for, and it is without prejudice. So if they accept it, great. Or if they want to discuss it, wonderful, open to that. Otherwise, we look forward to receiving their response. And once we receive it, we prepare a reply within 10 days and we book a court date. And I can tell you today, if I commence court proceedings, which we did this morning, the dates are May of 2021. Beautiful. It's a frustrating process to go to court in the middle of COVID. So, we definitely have to be able to present other options to our clients and encourage settlement for sure, especially in today's day and age. So the case conference stage, again, I'm happy to send you slides. I just presented at the Law Society and we prepared a slide deck for the Law Society on how the process works for self-represented people, the entire steps in family law proceedings, and cheat sheets on what are the documents that need to be filed by self-represented people, which actually I just found out is being used by lawyers as well for the family law basics course in mediation, which is interesting. So definitely happy to forward that if anyone's interested in that. The case conference stage, we often tell the clients, it's a process of exploring settlement options at that time with just the lawyers, not necessarily the judge. The judges are very, very reluctant to talk about the case at the case conference. All they want to discuss is, do you want any additional financial disclosure? What are the procedural orders? And of course, they're willing to make a court order with respect to child support on that date. If nothing happens on the case conference date, the next court date you're looking at is a settlement conference date, when the judge will actually offer a critique or their opinion on the merits of each person's case, and also have you complete an entire trial scheduling endorsement, which truly I believe has happened now. It's a new process that has been introduced because I think it gives the clients a bird's eye or really a clear picture as to the expenses associated with trial and what's required at a trial. And then we have the trial management conference stage, where everyone has to show that they're prepared for a trial, and eventually we proceed towards a trial. So average life of a family law case can be anywhere between 0 to 4 years. That's really how court looks, what court looks like. All of these court dates can be multiplied The judge may decide we're not ready to go to a case conference, settlement conference, and do a repeat case conference. Or in the middle, we may have to bring a motion because somebody needs support or somebody needs money from the house, or the children's lawyer may get involved, or there is no access. There can be multiple complications which require somebody to move away from a straight, streamlined process and bring emergency motions or regular motions to address multiple issues, basically.
You had mentioned from the outset that you can go through mediation or alternative dispute resolution, even negotiation, without even bringing a third party in before you go into litigation. And then you mentioned sometimes when you file the paperwork to commence everything, you send out an offer to settle. Do you think that do you find success with that, because it kind of gives a deadline of 30 days to either respond to the offer or file your reply to the documents?
Correct. So that's precisely the reason why I do that. Sometimes, for example, when the parties are separating, there may be urgent issues that need to be addressed, like spousal support, child support, or sale of a home, or critical decisions. And, people tend to procrastinate when it comes to mediation or negotiations. They may not give me financial disclosure and intentionally frustrate the process, especially when a person is self-employed. So I find that when I have that little stick that you have to provide it within 30 days, they are more willing to come to the table and have discussions and discuss that offer to settle as well. So that's definitely the reason why I often do it. I have to kind of gauge, depending on the facts presented to me, which case will work for it. Because if a person is a straight T4 employee, for me, it's simple, because when my client brings her documents, on the right-hand side corner, I will have his information with respect to income as well. So that's an easy peasy. The problem is when the other side is either incorporated, partnerships, self-employed, etc., that my client may just be lacking information, or I may have a client who's purely not sophisticated enough and I need to get more information from them. So that's when I have to use these methods, basically.
Now, in dealing with family law, certainly there's a lot of emotions at stake, and certainly, is there a way to perhaps, maybe you don't necessarily have to do this either, is detach yourself from kind of the emotions with your clients there, and then sort of being more objective with the next steps in their matter?
So I've worked on a pilot project with, actually the findings were pretty intense, with the University of Toronto on vicarious trauma, because for whatever bizarre reason, I have some of the most complicated cases in the region of Peel when it comes to family law. I've had the dubious honor of my clients, unfortunately, being murdered, my clients being abducted, my clients being on the witness protection program, and a lot of bad that's happened to them. I ended up as part of this, and there was a time when I refused to take on cases for a while which involved domestic violence, because I found that I was jaded. My definition of domestic violence was very different from the regular layperson's definition of domestic violence, and I had to be guarded because to each one's own, and I was getting very critical of my clients. I had to take a pause and say, for a while, I'm not going to take these cases, and come back to it with fresh perspective, and then start taking cases. In terms of how do I deal with it, as we were discussing before, I incorporated my dog Truffles into the process pretty early on in the year 2009. He started coming with me to the office, and I basically had him certified as a therapy dog. I find that it works for my office and the kind of practice that I have, because it's kind of strange. Like when I have a victim of violence present in my office, he can sense it for sure because he's trained to do that. As soon as they start crying, what would normally take them half an hour or 45 minutes, when you have a dog in your face, instantly it's just like, oh my God, he gets me. And you see them start to glow and their expressions change and they tend to calm down and they have somebody to stroke. And you can kind of see that it's pretty intense for them emotionally, that there's a recognition, not just from me, but from my dog as well. And even during my mediation process, I do watch my dog to see where he leans towards and which person he goes to. It's kind of strange, but it helps me in determining the power imbalance between the parties because he picks up on it. He's a lot smarter than I am when it comes to this. So that's one of the integral things that I incorporated. I do have signals that I will give to my staff also because there are certain triggers that you have when something's happened, and my staff is well aware that that's Kavita saying, you know what, I need out of this discussion at this time. Take a break for 5 minutes, come back, refresh, recharge, and continue with the discussions. I live very, very far from my office, and I find that's very helpful to my practice because by the time I reach home, I've had tons of wind down time. I listen to my music, I listen to my podcast, I take time to calm down. I don't take calls, I don't talk to my family. My family will receive a call from me when I leave, and they have strict instructions not to speak with me because I don't want to get into a fight, nor do I want to pass that on to them at that point of time. So I need that wind down time in my practice 100%. Also integral to my practice is that I will always, always, always work collaboratively with multiple community partners. So the minute I get my first phone call, I will usually try to figure out if this person requires additional support. I will connect them with a community support worker. It could be a women's support worker, it could be a counselor, it could be a therapist, depending on who needs what. It could even be somebody who's going to help them getting a legal aid certificate or find a place for them to stay or finding them a translator. Or I have a constant flow of clients where I will reach out to my client and say, hey, you've gone through this. Would you be willing to support this particular individual? Can I pass on your number to them? And never once has a client said no to me because I've always had that ability to connect my client to a former client. And I'm not breaching confidentiality. Somehow there's a little bit of camaraderie there, and they're able to trade stories, and it's kind of like a peer support group. So I find these things do tend to work very effectively. I confess, every single client of mine has my cell phone number. I'm very particular about it. I want to nip any major issues at the initial stages itself. I do not want it to bombard or become worse than it needs to. Sometimes the client would simply be asking me questions like, you know what, he's not brought back the child and it's been over 5 minutes, and all they need to hear from me is, it's okay, it's fine. If he doesn't bring them back, I will write to opposing counsel right away, instead of them losing their mind and calling the cops and then getting arrested and the kids witnessing all of this. So there are definitely things that have evolved over the last couple of years that I've put into practice. But in terms of dealing with vicarious trauma, you need to have a good support system. You have to have a strong family foundation. And even though I'm a sole practitioner, now just two of us here, I need to be able to pick up the phone and rant and vent and talk to people and share my emotions with people. And I find that that's definitely helpful for sure.
You mentioned obviously that you've kind of downsized to just the two of you there. How would you compare the experience now to when you had much livelier, let's say, office, and then even compared to the experience you had before you went out on your own? What can you share from those three different kind of aspects of practice?
So I found that working in a firm was not for me. And the reason it wasn't for me was because my way of practicing law is I'm a firm believer in access to justice. I don't necessarily believe in the billable model. I get that everyone needs to make money, but I'm not going to be billing for photocopying, faxing, or dictating to my law clerk and then me proofing that letter. That's not the way I work, and that was not something I was okay with either. I find that it is very, very hard for family law litigants to seek representation of any kind or afford it as well. So the bigger the law firm, I found, if you're not earning the income bracket of 150 and over, it was very difficult to provide them with competent representation or take them to the end of the matter all the way up to trial. So I needed to be able to offer something different to them. And also, most of the law firms, at least in Ontario, tend to work on a profit split basis, which was not an option for me as well. I was of the opinion that if I'm working so hard to share my profits with somebody, merely because they're providing me with a room and sharing support staff, it's a huge chunk of change, which really bites into what my take home would be. And that realization hit me early on. And I just was not okay with that. Plus the flexibility. I mean, in this era of COVID, it's different. You're able to work from home. But unfortunately, my employer at that time, and we find that most of the articling students and junior associates who I coach or mentor still tell me that, that flexibility still doesn't exist. There is a certain expectation when you enter into the practice, and you are doing, for the most part, the grunt work. Seniors may not want to come in, but you're expected that as just lawyers starting out, you will basically get those signatures from clients and make yourself available at odd hours and stuff. So it wasn't for me. But when I set up practice, it was amazing. I loved it. 2008 to 2014, it was a really, really good run. I had amazing people in my office who I'm still in touch with. So there's never a dull moment. I get contacted by them ever so often, without fail, at least once a month for something or the other. But I mean, what I did find was I personally found it hard to delegate. And I also found that everything that goes out the door has my name on it. It's me, it's my brand. So if I don't oversee the work, then I have no control over it at the end of the day. It may be minimal oversight, but it was still oversight that was required. So that just was not for me, for sure. And it was problematic for me. So I did not want to continue with that model of work. And by then, I'd come to the place where my practice was slowly evolving into the mediation practice as well. So, in order to be able to offer that as well, I needed to change the way I was practicing. I needed something which was a lot more congenial environment for my clients, and it just gradually started to evolve. I mean, it's a little difficult when you're working in a practice where you have 14 people. You have to, when you walk through the door and you're walking in at 12 o'clock and you decided to take a pit stop at Winners just because you felt so and the rest of the staff is working, that's a little difficult to justify. But at the same time now, I'm at the place where I have three children. Oldest is 18, my twins are 12 years. And I will work the weekends if I feel like it. But for the most part, I take 1 to 2 days off during the week. One, because grocery shopping is a lot easier during the week. And two, in the summer, going to Wonderland or to the cottage or spending time with the kids is a lot easier during the week. So having that flexibility is amazing. My clients love it. My clients love the fact that they can bring their children in here. They love the fact that I work weekends. They love the fact that there are times that I'm here in the evening at 10 in the night because my kids are asleep and I'm working, 10 to 12 in the night, which does happen. Yeah, it sounds crazy, but we are not traditional in terms of a 9 to 5 work hour, that's for sure. And it's amazing to be able to offer that to our clients.
Now, you mentioned access to justice, and you were talking about slides you put on for self-represented parties. What experiences do you have in seeing and working where the other side is self-represented, and how does that affect the entirety of the process from your end?
So I deal with a lot of self-represented that are my own clients, and I also deal with a lot of times when the other side is self-represented. If the other side is self-represented, I'm always reminding people, be it my associates or other lawyers as well, you have to respect the other side. There is a lot that's going on. They deserve the respect. It is not easy to find, to understand the litigation process, to understand the paperwork that's required. Be patient with them. I'm not saying in any way, shape, or form that I have to increase my client's bill by advising the other side who's self represented, but I am definitely saying, point them in the right direction. You could simply say to them, you know what, look at the Community Legal Education of Ontario website, or look at the Law Society website, and here are some cheat sheets, or with your client's permission, have that discussion, because honestly, the process will be a lot more smooth sailing if you are willing to communicate with the self-represented other side, for sure. And maybe even suggest to them, you know what, there's a paralegal available to commission, or here's a lawyer who's willing to provide unbundled services, or just basic information to them. There's nothing wrong with that at all. I strongly advocate for that, for sure. But I would also say I rarely ever talk to them over the phone, because it does tend to get misrepresented. If I am talking to them in person or over the phone, it would usually be with my client's permission, and I will have a witness present. I'll have a witness present because I don't want to end up in a situation where I'm faulted for what I'm doing, and I want somebody else to be able to provide an affidavit as to what actually transpired at that point of time. But if I have a self-represented client who's reaching out to me for unbundled services and says, you know what, all I want you to do is give me tips on what I'm supposed to do at tomorrow's motion. I will look at the paperwork. I will underline for them the issues, have bullet points for them jotted down on how they should address the court, what they should wear, what exactly they should be talking about, preparing basic tip sheets for them and guiding them with respect to that. There are times that I'm only retained to provide unbundled services on a limited scope for materials. It could be that they say, you know what, just prepare my application and I'm flying solo till I need you the next time. So I offer that service as well to them. Or like today, I had a client who is ready for trial and they cannot afford to have a lawyer for trial. And basically, I blocked off 5 hours, sat with them, reviewed the paperwork. They paid me for that, gave them tips, and that's the way I would deal with a self-represented litigant. So it's time for everyone who's providing legal services to evolve, because there are no options out there. It's just not possible. The way we bill, that model has to change for sure, and we have to start getting creative. We need to start focusing on the service model. Just like, if you go to Jiffy Lube, like you have the option to change the oil yourself in the car, but you go to Jiffy Lube because you don't want to get your hands dirty or put oil where the water is supposed to go to change the windshield wipers, right? At the end of the day. So yeah, that's why a person comes to lawyers, but you still have to be affordable.
Right. So, certainly for my students who are waiting, the Law Society has the process here with the creation of a family law services provider. I think it's FLSP. That's in talks and in the consultation stage. I mean, is that a potential solution for the access to justice, or is there anything else that can be done by existing practicing lawyers? Is it something where legal aid can kind of step in? Is it more, as you mentioned, these unbundled services that can be done? Do you have any other thoughts of access to justice, since you seem very passionate about it?
Well, I mean, definitely, I think, a lot of lawyers are opposed to paralegals coming and exploring family law or contributing towards it. I'm not necessarily opposed to it, but I would be a little concerned about if the paralegals are not adequately trained to provide those services. I feel that the intersection of family law with other issues is so vast, and it requires you to have a better understanding of multiple different areas of law, which is hard to cover in the paralegal program itself. So for example, there is definitely an interplay between estates, taxes, and family law, immigration, family law, criminal law, family law, or if a person is receiving compensation from work, severance, and the impact it has on family law. So taking all of that into account, like it is just a little harder to run with it. So I often say, be it a lawyer, be it a paralegal, be it any service provider or even mediators, because not all mediators are lawyers, right? So my argument for paralegals is, if you're permitting mediators to assist clients in resolving property related issues and deal with support related issues, why are we prohibiting paralegals from doing the same, right? But ergo, my argument on the other side is, well, I also feel that there's a certain protection when a mediator is doing that, because they do send the clients out for independent legal advice to a lawyer. So there's a check in place when it comes to that, be it even for the one-hour consultation. So my advice to everyone would be, know your boundaries, know your limitations, right? And there's so much that goes overlooked, that's overlooked when you're providing services as a family law lawyer. I'm often the second, third, fourth lawyer on the file, and I mostly take over files from existing lawyers who are kind of like, I'm done, I can't handle this, this is a mess, this is way above my pay grade, Ms. Bhagat, can you just take over and run with it, right? So I'm the cleanup crew at the end of the day. So I've seen the disasters which have occurred prior to me, be it whatever kind of lawyers, paralegals, mediators, whatever it might be. So know your boundaries, know your limitations. There's enough out there. There's enough work out there. We just need to find our comfort zone and be able to offer that to our clients, right? So again, with respect to access to justice issues, I welcome service providers, but I also fear that people need to be conscious and aware. I often say to people that if you look at it, at minimum wages, you can make $29,000. So as lawyers and paralegals, if we are billing at $300, $400 an hour, it's a king's ransom. Like, it's just not feasible. So in today's day and age, when the requirement from us, we don't even need the overheads of an actual physical office and can run with it within the comforts of our home with a laptop and, just a printer beside us. Why do we have to bilk our clients to this extent? Why can't we offer services which people can actually afford? And yes, I get the concept of paying for the experience that a person brings, because truth be told, if a lawyer is taking 6 hours to do the job, I could end up doing that in 1 hour because I've had that amount of experience to be able to provide that service. And that's what I'm billing for, right? So we need to be understanding of that and also be able to guide our clients saying, you can handle this work, I can handle this work. There has to be a lot of DIY in family law because there is a lot of scope for it and we have to work with them on that, right? And they have the ability to do it. A lot of court documents are copy paste. So why not encourage them to assist themselves? Because again, an educated, informed client is the best client that you can ever ask for. And God knows if this matter is going to proceed to trial, you will so appreciate that the client knows every single thing there is to know about their particular matter.
Right, perfect. I think there's a question here from one of my students. Bryce, you can unmute.
Do you do mediation arbitration for? Hi, how are you?
No, continue asking. I'll wait.
Okay, so do you do mediation or an arbitration for children's aid family cases? I don't have the stomach for it, to be honest with you. It would be child protection mediation that you would be talking about. It is a very, very, you have to specialize in that area of mediation. But have I trained and coached mediators who want to do it, including former CAS workers? Yes, 100%. You really have to have the stomach to be able to do it. I don't know if that answers your question, Idris.
Yes. Thank you very much. That's answered.
You're welcome.
Hello, thank you for being here. So there's just two quick things I wanted to ask, really interesting. You mentioned, interestingly, about how you clean up messes from either paralegals, mediators, whomever, right? And I would say that probably has a lot to do with how much you breathe law. rather than how good your schooling might have been. Do you know what I'm saying? Like, it's just a breadth of experience that makes you able to clean those messes, right? Now, with that in mind, I'm curious. It seems as if there might be a little work that needs to happen on the lawyer side as well. Like, I mean, I'm a brand new student. I'm just walking into this, right? So if that's the case, then maybe it might be beneficial to, let's just say that this family thing doesn't really go through for the paralegals and we still have to go back to the drawing board or whatever. Maybe there might be some need for having a delineation between, family lawyer A-rated. I can handle cases that have, 6 appeals or whatever factor you might want to add in there. That's one idea. Second question I had, very interestingly, you mentioned something about access and how the legal aid system doesn't make any sense, which I'm fully aware of. Have you, maybe not necessarily you, but have people in your profession thought about prorating based on income?
Yeah. So I provide services on a sliding scale depending on parties' incomes. So I will do mediations based on that. I will provide legal services based on that. I will definitely ask for their income information because legally it doesn't necessarily do a perfect check, but I will first get their financial disclosure before I offer it because I don't want to be blindsided for sure, but I will offer services on a sliding scale for sure. 100%. I do pro bonos as well, but they have to be extreme cases.
Yeah, I mean,
if I'm going to consider it.
You can't just be handing out candy.
Practice.
Yeah, you can't hand out candy like that. Exactly.
Totally.
Yeah, but that's interesting.
Yeah, I mean, and a lot of people are starting to give it due consideration in offering that. Sorry, Bryce, remind me of the first question again. I lost track.
It was a question, but it was more of a commentary on what can be done to reduce your workload as a mess cleaner, right? So, if you're a professional lawyer, you should kind of know what you're doing, right? I mean, I'm looking at this from perspective of walking into being told that I need to know what I'm doing as a paralegal. Do you know what I'm saying?
So, I'm very, I mentor at this point of time, personally mentor and coach. I think I've exceeded 47 lawyers at this time. That's how many I'm mentoring right now, right at this minute. So it's a very high number, but there's a reason for it. And the reason for it is that they need hand holding and they're not ready to do it. And I do lunch and learn sessions because especially when you're doing so many or mentoring so many, it's hard to pick up the phone and talk to each individual. And I also find that everyone has something to learn from the other's experience. So I leave it open, the lunch and learn sessions. It's basically an open house at my office. And incidentally, we had one, I think it was just recently, October 23rd, in my parking lot. And we all bought our camp chairs and we still continued with the lunch and learn session where everyone got their little doggy bag. And they open up about their difficult cases and where they are stuck. And I will assist them with it, and the rest of them are listening to it so that if they're ever faced with the same predicament, they know exactly what to do. So where I'm going with this is, one, if you're struggling, reach out to other lawyers. I have always reached out when in doubt to either a peer or a senior. And I remember this one instance where, unfortunately, my client was found murdered. And not many people have experienced something like this. And I didn't know what to do. I had an upcoming motion. I called the Law Society and they said, no clue, like, what are we going to do? So I said, well, I mean, am I supposed to go? The family wants to take over. There's a child involved. What am I doing, right? So I researched candidly. I found something similar. I cold called a whole bunch of people. I made friends with this exceptional lawyer from downtown Toronto who had experienced something similar, who's now gone on to be a judge. And I said, help, 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 help. I kid you not, I must have left over 20 phone call, voicemail messages, followed up with emails because I was that desperate. It paid off. He called me. I gave him my cell number. He called me in the middle of the night because he was in a trial. I still remember it was almost midnight and I was making my little one sleep and I get this call and I see this unknown number, which usually happens when a family law client ends up in jail, and I always answer. And this really strong voice pops in and I have this in-depth conversation with him. But hey, that's why we need to be able to reach out. And the best advice he gave me, I knew exactly what to do going into court, right? So it was helpful. So, no one, we don't know everything going into the practice of family law, and we have to be open to the idea of reaching out to our peers, colleagues, and seniors, and there's absolutely no shame in it at all. So I strongly encourage people to do that. In terms of the delineation between paralegals and lawyers, I think there are lawyers who are very, 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 very dependent on their staff, be it law clerks or be it paralegals or be it NCA students. And they take credit for the work that the law clerks and paralegals and NCA students do for them, right? But ultimately, the liability lies with somebody who is signing off on these documents, and there are checks in place. It's not to say that the lawyer's work is 100%, but there have to be checks and balances in place, and there has to be certain rules. Like, I kind of compare this to the concept of, say, a dental hygienist and a dentist, right? Ultimately, if there is something very, very complicated, the dentist will take care of it and walk in. But there's still a lot of room for the dental hygienist to do almost 80% to 90% of the work. And why not? Why not? Should be doing it. But let's have those checks and balances in place, right? So we need to make room for that and create a system like that. But what I am opposed to is something similar to the immigration consultant system, which frankly, in my opinion, is a complete total disaster, because there is really not much of an overseeing body there. They are doing everything that a lawyer would do, including appearing for tribunals, submitting all of the forms. And we read a lot in the news about how the common people are being cheated, right? So it's just unfortunate, and that's what we need to prevent. That's exactly what we need to prevent.
That makes
That's
sense.
all I'm asking for.
Yeah, that makes a lot of sense. Thank you.
Right?
I got to dip to my exam really fast, so enjoy. Thank you very much.
So Kavita, another part that I mean we touched on a little bit is what happens when you play the role of in a matter as a mediator. How do you prepare differently than if you were representing, let's say, either of those parties? How does it work differently from your mentality?
So if I'm a mediator, what the process, the way it would start is that I would get on a phone call with both the parties for a 10 to 15-minute consultation just to explain the mediation process. And if they have lawyers, I still insist that I have that conversation, even though the lawyers have 200% assured me that they have given their client the spiel about mediation. I still feel more comfortable to have that conversation with both of them. Then I will bring them in individually for an initial intake and get comfortable, getting to know that my intake process is more about screening and getting to understand the issues and making sense of what's happening. And I struggled when I first started doing mediations because I found that as a lawyer, I'm very positional, and I want everything by the book, everything by the law, the four corners of the law. This is how I'm going to solve this. But as I've evolved over the years as a mediator, I find that it's well within my ability as a mediator to draw a circle within the square. And that's what I try to accomplish as a mediator, because there's more than one ways to build this cat. So why not offer creative solutions, right? Why not come up with that? So it's something that I'm extremely fond of. I feel that mediation is definitely an option that should be explored. I will do that intake again with the clients only because when there are lawyers present, it is in our blood to be positional. It is part of our profession to protect our clients and kind of tell them this is what your entitlement is. Don't give up on that. But what we tend to forget is clients just want to be done. They want to move on with their life. And sometimes it could be as simple as the client saying, I just want him to say sorry to me for cheating on somebody else, and I'm willing to give up on everything, which truly it happens. It's just incredible. Sometimes that's all it takes to mediate a beautiful agreement, right? So neutrality is the toughest for me when it comes to mediation. And there may be times when I'm choking and I'm thinking, oh my God, like she's entitled to so much more. He should be getting more time with the children. No, 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 no. Stop yourself. Stop yourself. Control yourself. This is what they want. If they're good with this, I'm good with this. It's not my goal to tell them you have to stick to the letter of the law. Ultimately, they need to be happy with it and they need to live with it. And I'm sending them out to lawyers. So, if the lawyer's not okay with them signing it, they have to figure out another process.
Perfect. So thank you so much for joining us today. Lots of information there about family law. And certainly I would appreciate if you do get a chance to send me some of that as supporting materials that I can share with any interested students who want to learn more about the family law process. So perhaps maybe you have any final words of advice for paralegal students who may get an opportunity down the road to practice in family law, and they have, or they may work in a family law office in a support role for a family lawyer. But anything you could share with them if they choose to get involved in family law, or any just general advice as well for succeeding in the law profession.
Do tons of CPD courses. If you're going to take on financial issues and want to excel in it, take continuing professional development courses for sure, so that you know the interplay between the family law issues and the financial issues. Have an elaborate network of professionals that you can reach out to if there are challenges with immigration issues, criminal issues, piercing of the corporate veil, reaching out to a corporate lawyer. Have tons and tons of connections. Start small, start with the basic concept of trying to figure out how to generate a continuing record to do a divorce. And then start with basic issues with respect to access or custody, and then grow along the way and take on more interesting issues. Start with support and then move on to property related issues. And do not touch pensions unless you are very, very, very good at all of these issues first.
Perfect. So thank you so much again for joining us. I wish you all the best in your practice. And thank you everyone else for tuning in. Bye, everyone.
Thank you for having me. Have a great night and all the best with the exam tonight.